Hey, it's Chad Brown. Welcome to another episode of the Disability Expert Podcast, where we talk about all things Social Security disability. And I'm here today, once again, with my trusty sidekick, partner in crime, fighting the Social Security Administration, Aaron Dalton. What's up, man? How you doing?
Good to be back.
Yeah, all right. We've got a very important show today. They're all important, like if you're trying to get disability. But
this might be one of the more important ones.
I mean, it's pretty important.
Pretty
Like I don't want to I've been known to they say it like Christmas, I overstate, and like this is gonna be the greatest gift ever, and it's like socks or whatever. But we could be at risk of doing that today, but I really don't think so.
I don't think so.
All right. Consultative examinations. One of the most important things that's going to happen to someone in a Social Security disability case is the Social Security Administration is going to very likely not believe any of their doctors. They're going to say, we think we need to send you to one of our doctors to have an exam, and that doctor is going to be infinitely qualified, probably in something like pediatrics, hasn't practiced medicine in 9 years, does 397 consultative exams a year, and it all just feels like a sham sometimes.
Yeah.
You agree with that?
Pretty much.
Okay. That doesn't change the fact that Social Security Administration gives this tremendous weight. This is one of the most probably, I don't want to say it's the most heavily weighted piece of evidence in a Social Security disability file, but it's certainly one of the ones that draws the judge's attention. They look at the file, they look at your evidence, and they do see this as something that they get right, which is an objective piece of evidence, in that it's an actual exam that has findings, supposedly. We'll get to that question. We'll get back to that. But it's also independent. It's independent. And because of that, because you have what would consider to be an independent objective exam, the judge is going to look at that and say, hey, this is an independent source that's giving me real information that I can use to determine if you're disabled. The other thing I think it really is important is this is probably, unless you go in person to do an SSI application, or you happen to go in to do your application in the Social Security office, this is going to be the first time, usually in the disability process, that a claimant is going to actually sit down and talk to someone about their case. So all kinds of ways you can screw that up.
Yep.
So here's what we're going to do. I want to go through and talk about what are consultative examinations. What are they? Why are they ordered? How are they used? And then I want to jump in and see if we can give some real practical advice to people who are pursuing disability, breaking up into 3 stages. Let's look at what you should be looking at before the consultative exam, what happens during the exam, and importantly, what a lot of people don't understand, what needs to happen after the exam. If we get done, if we have time, which is always the $20 million question, we got a top 10 or top 7 or something. I don't remember what the number is. We got a top list of things you need to do. So with that being said, what is a consultative exam?
Simply put, consultative exam is an exam that Social Security schedules and pays for to help them try to evaluate your case. There's 2 main types of consultative exams that we typically see in a file. Generally, it's either going to be an internal medicine exam with a nurse practitioner, PA, or MD that's doing range of motion testing, sort of looking for physical signs and symptoms.
Right.
Or it could be a psychological consultative exam with a psychiatrist, psychologist, mental health therapist that's looking into more of the mental health aspect of a case. So some cases have one or the other. Some cases have both.
Right.
And they can be scheduled at different times in the claim. So sometimes it's scheduled right off the bat with the initial DDS decision. Sometimes they wait until after you've gotten your first denial, and as part of the reconsideration level case development, they might order a consultative exam. Some files I look at have 4 consultative exams because they ordered a mental health and an internal medicine at each stage of review.
Right. And then again, sometimes judges, if you get to the actual hearing, you get to the hearing.
Sometimes judges can.
Right, you get to the hearing and the judge doesn't think the evidence is sufficient, or they don't like what the evidence shows.
Yes.
They'll send you for a consultative exam either before the hearing or sometimes after the hearing.
Sometimes after the hearing.
Right. So the The consultative exam, though, is going to be ordered by the Social Security Administration. And generally, it's that whether you get an exam is based on the types of the allegations that you've made about your impairment. So if you've alleged you're depressed or anxious, or maybe have some learning difficulties, you're likely at that point going to get a psychological consultative exam.
Right.
And if your complaints are largely physical, I have an issue with my back or an issue with my shoulder, or, largely orthopedic type problems, often get sent for a consultative examination. So the fact that they order it doesn't necessarily in and of itself answer the question of what its purpose is. You would think that its purpose is just to obtain information and to be charitable to the administration and the DDS or whoever's ordering it. I think that's part of it. But at another level, I think it's important for people to understand the role of this consultative exam in their case as it moves through the process, but ultimately is in front of the ALJ. So can you talk a little bit about how, in your experience, the examiners and then ultimately the judges, how are they going to use this consultative exam? So what's the purpose behind it other than just in gathering information?
There's a lot to unpack there.
Okay.
So I'll start with this. These might be one of the most single important piece of evidence in a file. Social Security files can get huge, thousands of pages, but even when I'm looking at a file, the consultative exams are one of the first things that I'm looking at. If they're helpful, a lot of times that helps me figure out, okay, where are we going with this case? If the consultative exam is helpful, that's usually a pretty good sign that we've got a very strong case that we're looking at.
Right.
Sometimes the consultative exams are not helpful and the case is still very strong, but it just kind of helps me get oriented to how much are we going to have to fight on this thing. And I suspect that the judges use it very similarly. They're looking at the consultative examiner's opinion. If even the consultative examiner agrees that you're disabled, maybe this is a case the judge should just go ahead and approve.
Yeah, I mean, I agree. I think sometimes you even go into the ALJ and they'll ask for your opening statement, and your opening statement sort of starts something like, "Well, Judge, even the consultative examiner thinks my client's disabled. I don't even know why we're here." It's, if they think they're disabled, then surely they have to be disabled, right?
Exactly.
Yeah.
The other thing that I find consultative exams helpful for is providing a good treatment history summary. So when you're looking at the medical records with your standard provider, sometimes you're jumping in, 5 years into a 10-year relationship. And so you're kind of getting in midstream and it's hard to figure out what's been going on. But with the consultative exam, they typically take 1 to 2 pages to really lay out a detailed summary of what the person they're examining is telling them's wrong with them. So that can be a good way to get oriented to the larger history and to really make your case, as it were, with whoever's looking at your file, because they're going to be looking at that examiner's report to figure out what you're saying is wrong with you in a brief, easy to digest summary.
Right. And I think one of the things that clients and claimants need to understand is that this is an important moment in the development of your case. Now, every case doesn't have a consultative examination. You don't actually have to go, and if we get time, we'll dive into why that might or might not be a good decision, sort of general opinions about that, which actually differ. But at a minimum, the client needs to understand that you're highly likely you're going to have a consultative examination ordered, either physical or psychological. It's going to be an examination where you're going to not only give a history, you're going to be examined. Purportedly, you're going to be examined. And how you manage that exam in some respects is going to impact your case. So with that being said, once you are scheduled for a consultative exam, I think most people, because they don't understand the significance, because they don't understand exactly what's going to happen, they either sort of get angry or they're sort of nonchalant about it. And I think both of those are a terrible sort of response to the ordering of the consultative exam. So what I want to do now is, if we could go through, I think it's important if you sort of look at I think it's easy to look at these in phases. What should you be doing before the exam in preparation for it? what you're going to need to do during the exam, and then we'll touch on what happens after the exam. So let's talk about this. So let's just take hypothetical client. We'll use hypothetical client Nancy. Nancy's got, some pretty significant physical problem, maybe has a little bit of depression. She gets scheduled for a physical consultative exam, calls up the office and says, "Hey, I've got to go to a consultative exam. I want to talk to Aaron." Okay, so if that's necessary, then how would you advise her, or how does our staff advise her based on things we tell them? How does our staff advise people when they call them, "Hey, these are the things you should expect, and this is what you need to do before the exam"? What would be some tips you would give them?
Yes. So a couple of things we always try to help clients understand is one, just the nature of the exam itself. So a lot of these are actually scheduled on the weekends. It might be a Saturday. Social Security hires this person to do 7 exams on a Saturday. So these are not long drawn out things. You might be in and out in 30 to 45 minutes with the examiner. And the examiner's paid a flat rate to do this exam. So they are not reviewing a whole lot of records before your 30 to 45-minute time slot. So I say all of that because when you're getting ready to go into the consultative exam, it's really important to have a good timeline of your medical history. So you need to go in and have a good idea of, in the last 10 years, what were the dates on the major surgeries that I've had, if that's relevant, or what are my MRIs saying? We don't typically recommend that clients bring in a big stack of medical records because that's not going to get you anywhere with a doctor that has 30 minutes to do your exam. But if you have one MRI that's recent and it really explains what's going on with your case, by all means, bring that in. That's quick for the doctor to take a look at and can kind of help get the doctor oriented to, okay, well, the doctor's seeing this on the physical side. Here's the MRI that backs that up. So just having that sort of succinct idea of, okay, this is what I'm going to tell this person is wrong with me. I can give them a brief overview of my treatment history. And then once you actually get in there and the doctor's gone over that with you, they're going to do some range of motion testing. So be ready for that.
Right. And then I think it's also important for people to understand, like, this is not the day to exaggerate, and it's not the day to understate. And so when it comes to preparing, if you use a cane, you should use a cane in the exam. If you use a walker, you should use a walker. If you wear a back brace, you should wear a back brace. If you wear glasses or hearing aids, you should wear your glasses or hearing aids. The goal is for the examiner to be able to do an objective examination of you as you are at that point in history. And I think it's important that you're sort of business as usual in terms of how you're functioning.
For sure.
That needs to be the same when you go into that exam.
For sure. And that brings up another good point, that the examiner is not there to treat you. They will not be prescribing medication or courses of treatment. They are there to observe you, do a couple of tests, and then send you on your way. And so exactly, showing up kind of as you are is the best thing that you can do.
And as we sort of move into helping people understand what to do during the exam, I think one of the things you need to understand as well, though, as you're preparing, is that very often your examination observation may very well happen before you ever walk in the building.
Oh, absolutely.
I mean, it's the number of times that I've read reports where it said we observed the client in the parking lot before they came into the examination, and they were walking perfectly fine with a normal gait, and got into the hearing room with a cane and were hunched over. So one of the things I think it's important to understand as you transition from preparing, that examination starts the moment you pull into the parking lot in many cases, not just when you actually go in and meet the doctor. So let's say Nancy made it to the parking lot and she used her walker correctly, because she always uses her walker, and you come into the exam. Now that you're in the exam, on sort of exam day, what kind of tips would you give people to help them get the most objective and accurate findings out of that exam?
For sure. So a lot of the exams will let you bring in a relative or somebody for some emotional support. If you're comfortable with that, that can be a really good thing to do, because it does feel like there's a lot of pressure in that exam. And so having somebody there that you trust and can help you make sure you're getting things correct
Sure.
can be helpful. Also takes some of the pressure off having somebody else drive you there. You're not worried about, am I going to find it? Am I going to get there on time? Some other things during the exam, the doctor is going to be asking you to do some stuff. If it's a physical exam, they're going to be doing range of motion and various testing. They might ask you to squat, to stand on one leg. So don't do anything that you feel like you're going to get injured doing. If you are not comfortable doing something that the examiner is asking you to do, tell them that you're not comfortable and tell them why.
Right. Yeah. I mean, I think it should go without saying, but after reading literally thousands of these over the years, we're going to say it anyway. You need to be honest about what your limitations are, and that works both ways. You don't need to. The words that will kill your consultative examination very quickly are, "I'm fine."
Oh, yeah.
It's not the day to be fine, because if you're truly fine and you don't have any issues, then you probably shouldn't be in the process. But usually that's not accurate. It's either from people feeling like there's pressured by it and they want it to be over. Sometimes they're still dealing with the realities of having disabilities and having limitations, and they want to marginalize them or minimize them, not marginalize. They want to minimize them so that maybe they don't have to say out loud, "I can or can't do this thing." So the first thing we tell people is, don't minimize your symptoms, but by all means, don't exaggerate.
Yes.
I mean, if you can't do anything at all, truly, then you probably weren't able to walk in there. You probably weren't able to get on the table. That doesn't mean that you don't need to take your advice and not do things that would injure yourself. But at the same time, if they say lift your arm and you're like, "I can't lift my arm at all," and what you don't know is you're going to lift your arm to open the door when you walk out of the room, and now you're going to have massive credibility problems. I just don't think you can overstate enough. Exaggeration doesn't help.
For sure. And along that line, sort of always or never statements can really be another pitfall. If it's occasionally, say occasionally. Don't say, "Well, I never do this."
Yeah, and I think even in that line, I know we've got an episode coming up in the future where we're doing we're going to talk about how you engage with your doctors. I don't know. Stay tuned for that. I don't know when that's actually going to come out, but it's coming in the future. And one of the things I know in preparing for that future episode we've talked a lot about is the need for specificity in describing what's going on. Even occasionally or sometimes don't have enough framework. So in your preparation, if you have difficulty sitting, be prepared to give a good example. I still go to church on Sunday mornings. I can't sit through the sermon, which in my church is 25 minutes. I know that always at this point I'm standing up, which is about 15 minutes because I have back pain. That's a very specific example that gives context to your limitation that also down the road we're going to be able to make applicable in the trying to get the judge to find you an RFC that's less than the competitive employment. So I think in sort of in line with being honest and not exaggerating is also being specific.
Yes.
Yeah. I think one thing too that we need to touch on, unfortunately, is the reality that a lot of times our clients seem to be combative with either the staff or the examiner themselves. I can't stress enough how bad an idea that is. To go in and be and I've listened to audio tapes where our clients recorded the consultative exam, and I just wanted to go, "Oh no,
It's that sinking feeling. You're like, "Oh, this is bad."
this is really bad." And just I sort of just tell people, look, they may treat you well, they may treat you poorly, they may be nice and kind and helpful, they may be short and rude to you. But whatever you do, you need to be kind to them.
Yes.
There's just no recovery sometimes from you being combative or aggressive towards a consultative examiner or their staff. Finally, with exam day, I think people need to understand, you also need to understand that exam follows you back to the car.
Yes.
Because even if they don't watch you in the parking lot on the way in, they may watch you in the parking lot on the way out. And so just understand your exam is really from the moment you enter the parking lot to the moment that you leave. If you're being honest and not exaggerating, but you also don't want to give them the opportunity to maybe misrepresent something that happened outside the confines of that exam. Um, I want to talk a little bit about after the exam, just because I think people need to be aware of a couple of situations. One, sometimes the exams are not very thorough. And if that's the case, you need to tell your lawyer. There are stories that I've heard. I'm sure I've had a few clients say this, but you hear stories about people where they do an exam and they say, I wasn't examined at all. They said they asked me to do a straight leg raise, but I never actually did one. They said they asked me to take steps and turn around, and that didn't happen. They said they tested my wrist, but they never actually put their hands on me. When that does happen, if it happens, what's your advice to people? How should they be handling it when possibly the consultative examiner has abdicated their duty to do a faithful, accurate exam and maybe didn't do the things that they've reported on the paper?
Let your attorney know immediately. That is a huge red flag because the examiner has to send in a report saying, these are my findings. If you went for an internal medicine exam and they never touched you, it's going to be very difficult for them to say what your range of motion was, which means there's probably going to be some stuff that's made up in that report, which could be very damaging if all of your other records say you have such and such limitations and the examiner says, no problem. So if you have concerns that you weren't actually properly examined during your consultative exam, let your attorney know there's things that we can do, raise the issue with the state agency and say, hey, you need to schedule another exam. This examiner did not
Right.
do a proper.
And I think another thing that's helpful that not a lot of our clients do, but we encourage them to do is I think right after the exam, right after it's happened, it's really good to just take a minute. You can write it out. You can use voice memo on your phone. Just go through and describe what happened in the exam. I came in, the front staff person didn't have my name down. They didn't know it was me. They were rude to me. They were very kind to me, whatever it is. I went in the exam. I was in the exam room. My sister went in with me. I was required to do X, Y, and Z. Even if you don't know the technical names of the testing, just explain what happened. Because at least at that point, it gives us the opportunity to look and see, is this exam really reflective of what happened? Because if there's major differences, even maybe it might not reach the level of filing a complaint, we certainly could, add a statement to the record that says, this is our summary of what happened in the exam. We think there's issues here. Maybe not enough to file a complaint against the examiner, but enough to question maybe how the exam was performed. So I think that's important.
I would add two more things. The first one, if you have good days and bad days, it would be very helpful to note, did the exam take place on a good day or a bad day?
Right.
To be able to see, okay, well, maybe these aren't reflective of how you are on your worst days. Second thing, sometimes I have talked to clients who say, I was sore for days after doing all of those range of motion testing. But to have that documented in real time can be very helpful.
Yeah, and sometimes it might be, let's say you have a family doctor visit 10 days later or whatever. That would be a good time to say, hey, this is what went on. I had to go have this exam done. It's completely relevant to your medical care because this person examined you. And I've been having these issues since. So now there's another documented record that does that. We've got 7 things not to do in a consultative exam. I wanted to dive deep in these, but I am going to leave our listener with these. You can check these out in the show notes. Going to go through them quickly. Not going to give elaboration, but here they are. 7 things not to do in a consultative exam. Don't miss your exam. The stakes are high. Don't miss it. Don't go alone if you can avoid it. Take someone with you. Allow them to support you. Don't say I'm fine, especially if you're not. Don't try to push through pain to prove that you can do X, Y, and Z. Don't do that. Give an honest effort based on what your abilities are. Don't exaggerate your symptoms. Whatever you do, don't exaggerate. Don't be rude to anyone. Just treat other people like you would want to be treated. It's not that complicated. Just be kind to people. And finally, don't do anything that could get you injured. there may be things you can't do in this exam. And the last thing you want to do is end up with an advanced, more complicated medical problem because you were trying to please the examiner. Don't do that. All right, man. I knew this was a good episode. We should have done 2. Maybe we'll do another one time. That being said, that's all the time we've got. Another episode wrapped here, the Disability Expert Podcast. Subscribe, follow us, check out our episode. Until next time, take care.